able to procure an advisory opinion, who can believe her? Is she breathing confidence in that particular office? Should she not be held to account? Is she not bringing that office to disrepute? Honorable Senators, we submit that that particular charge has been sufficiently proved. On the question of the appointment of the chairpersons, again we prove that we have been able to dispose of our honorable members of the Senate to ask you to do your noble thing of exercising oversight over the county government of Meru. I have time and again put it on record that the County Assembly of Meru and the people of Kenya have a lot of confidence in the manner in which this house conducts its business. It's on that basis, therefore, that we have been able to appear before you severally, seeking and pleading for only one thing, that justice be done in the county government of Meru. And what justice are we looking for, honorable members? We are looking for justice of that particular person who is not able to access services, courtesy of bad governance. What justice are we looking for? We are looking for justice of that child we saw who was born on a karai, that child who cannot speak, that child whose fate is not even determined. And when the governor is put to task, says, I have just been made aware. How would you take that governor to be a responsible person? How would you take that person to be a person who is capable of enhancing good governance, delivery of services? How is it that she was not aware that that hospital is not functional? How is it that she is not aware that that hospital or dispensary has a functional maternity wing? She takes no bother to confirm why the hospital was not functional as at then. Even having been made aware as at yesterday, she still says, I am not aware. Is that the governor who is capable of running the county? Is it really the mistake of the part of the county assembly? Or is it the county assembly being invited by the misconduct and the misdeeds of the governor? Can the county assembly of Meru County sit pretty and watch things go south? Isn't it their responsibility to exercise oversight over the performance of the county government? Are they wrong when they invite the Senate to help and assist and facilitate the operationalization of the oversight function? That is all what we are asking for. That is all what we are asking for. If we were in the UK setup, this house qualifies to be the House of Lords. It's a House of Lords because it's capable of determining where the truth is and where the lie is. Evidence has been led from the county assembly. Grounds were approved by the mover of the impeachment that it is true the governor has transgressed and violated the constitution. When she was put to task to explain the circumstances that led to the revocation of that CEO, she simply said, it wasn't me. And how can it be that the governor can be allowed to get away with a forgery? Isn't it a criminal case in the first instance? And who has a burden of proof? The person who claims that the signature was forged appeared before the Senate. Her evidence was put through test by cross-examination, and clarification and verification was sought by the members of the Senate. Who then is lying? Is it Linda Kiome, or is it the governor? Can the governor be trusted? Put to task and granted an opportunity to bring even the original advisory, she simply said it was seated somewhere in Meru. Unfortunately, she mistook where the place of the trial. The place of the trial is not in Meru, it's before this Senate. Is that a conduct that is consistent with innocence? If she was innocent, if it was not forgery, why was it so difficult for her just to bring that one letter? Why could resources not be committed to make sure that as and when she was made aware that that is an issue, that a letter could not be procured 180 kilometers away from the place of the trial? What is she concealing? What is she hiding? Is she hiding scrutiny? Is that conduct again consistent with an innocent man or innocent woman? I urge you, honorable senators, to find it in our favor that we have proved that particular ground. That the letter that was meant, that the advisory that was meant to rebut our evidence in respect to ground one is a document that is a forgery. In the case of Philomena Mwilu, the Deputy Chief Justice of the Republic of Kenya, it was held that evidence that is tainted with illegality, it cannot be admitted. The admissibility of that evidence is in question. And having read the case of Ombora in the civil appeal number 21 of 2014, the Court of Appeal suggests that this is a quasi-judicial process. And it being a quasi-judicial process, the rules of evidence plays a fundamental role in the manner in which the admissibility of document is concerned. I sought leave of this House to have the document placed on record. They took no initiative. Why? Because they wanted to conceal the lie. They wanted to conceal the offense of perjury. They could not withstand the embarrassment that a signature was lifted. It matters not whether the governor is an IT guru. It matters not whether she is techno-savvy. It matters that a document was brought before you that is as a result of a forgery. We seek that you find it in our favor, that that particular ground was not defended, it was not controverted, and that the ground suffices to meet the test laid down under Article 81 as read together with Section 33 of the County Government Act. And then what is the threshold in terms of that particular charge? The threshold is that of, it lies between balance of probability and beyond reasonable doubt. That is what the case of Governor Wambora stated, that we are not supposed to prove. The burden of proof is not beyond reasonable doubt. It's not beyond reasonable doubt because this is not a criminal trial. And that distinguishes the case from the case that was quoted by Senator Kajwang, that this is not a criminal trial to seek the county assembly to prove the case beyond reasonable doubt to the extent of seeking the intervention of a forensic document examiner. It's on balance of probability. Whom should we believe? Who should we believe? Is it the person who has committed serious transgressions? Is it the person who is not in touch with the county? Is it the person who is in war with all the leaders in the particular in the entire county? Is it the person who is not even in good terms with his senator? Whom should we believe? Should we not believe leader? What personal vendetta would leader be having? She is not vying for a seat of governor. It matters not that whether she was a running mate to the previous candidate or not, but it matters that an offense was committed. We urge you, honorable senators, to find that that in revoking the appointment of CPA Virginia Kawira, Governor Kawira violated the Constitution. She violated Article 10 of the Constitution on the question of the rule of law. She violated Article 27 on the equality before the law and the equal benefits of the law, that Virginia was not subjected to equal protection and equal benefit of the law under Article 27. She equally violated Article 50, that she was not given a fair trial or a fair opportunity to defend her case. When put to task, she attempts to become a linguistic, to purport to differentiate between removal and revocation. When tasked to read the provisions of Section 58 and Section 59 of the County Government Act, honorable senators, she simply could not distinguish. At the end of the day, whether a revocation or a dismissal, it never followed the due process. The County Assembly was never involved. It violated that particular provision. And for that reason, Governor Kawira must take responsibility. Taking responsibility is not an act of cowardice. It's not an act of weakness. It's an act of saying, yes, I was wrong. It's an act of admitting when somebody is wrong. And that is what Article 10 speaks about, the question of accountability. And that is what Article 73, which Governor Kawira has violated, speaks about. Article 73, honorable senators, speaks about a person who holds the office of a governor or any other office in the Republic of Kenya, breathing confidence in that particular office. When Governor Kawira lies blatantly, openly to the whole world that she was able to procure an advisory opinion, who can believe her? Is she breathing confidence in that particular office? Should she not be held to account? Is she not bringing that office to disrepute? Honorable senators, we submit that that particular charge has been sufficiently proved. On the question of the appointment of the chairpersons, again we prove that we have been able to dispose of our burden of not proving this allegation beyond reasonable doubt, but on balance of probability that yes, Governor Kawira has crippled the operations of the Meru County by blatantly failing and ignoring and or neglecting to execute her functions as a chief executive of Meru County. That amounted to the violation of Section 4 of the Public Appointments Act, in that requires when the governor is bestowed with the responsibility of a duty to follow the provisions of the law. Can she be acquitted? How many times is Governor Kawira going to commit transgressions and get away with it? How many times? When she gets away with the transgressions, where do we leave the people of Meru County? Do the people of Meru County equally deserve justice? Should there not be a balance between the people of Meru County? Where should the balance lie? How should the balance swing? In whose favor is the balance swinging? I suggest and propose and submit that the balance swings in favor of the people of Meru County. They deserve justice before this house. They are crying out for justice. They are looking upon you to dispense with justice. And there cannot be justice by sending Governor Kawira back to Meru. The only justice that can be served, I suggest, is telling her you have failed in your duties, you've neglected in your duties, you've violated the Constitution, you do not know what the Constitution dictates. Remember, she swore to defend this Constitution. But she is one of the greatest transgressor of the same document that she's seeking solace and reprieve from. Honorable senators, Governor Kawira has come before you with dirty hands. She deserves no favor. She deserves no kindness. She deserves no kindness before this particular house, before this Senate. She has come to you with dirty hands. She is not even remorseful that a toddler was born in a Karai when there is just an adjacent health facility. If there will be no any other reason for sending Governor Kawira home, please remember the fate of that particular child. Remember the fate of that particular mother who got embarrassed on that particular day. Remember the interpretation that was done, that men and women had to make sure that young children do not go near that naked woman to see her nakedness. How many embarrassments will this house be treated to? Isn't that something that we need all to take cognizance of? Was that video proving failure of service delivery? Who is responsible of delivering those services if it is not Governor Kawira, who has proved on oath that she has failed? Who else should we hold accountable? Who else should we hold accountable? Should she even be allowed to hide behind the cultural card? She has said and submitted